Members of the council say the first two major recommendations that they made are working. It was part of the initial rollout of their project. The first was cutting down on the number of check-ins to the Al Cannon Detention Center. The other provides an attorney for everyone going through bond court.
Our jail is far more used today for more serious crime and not so much the misdemeanor municipal magistrate type charge.
Christy Danford is the project director for the CJCC, and she says they used hard data to determine how the jail was being used and then focused on keeping offenders who don't need to be in jail out. Those misdemeanor charges for things like simple possession of marijuana, shoplifting, trespassing, open container, and public intoxication, Danford says don't necessarily require a trip to jail.
An officer has the discretion to issue a citation, like a ticket, and send the person on their way so they could still be accountable for the charge, but not necessarily have their whole life disrupted by bringing them to a costly jail.
But they were more often than not being brought to jail.
Yes, they were. They very much were. Our number one charge admitted to our jail was simple possession of marijuana.
The CJCC worked with the big four agencies in Charleston County to accomplish the goal. The Sheriff's Office, Charleston, North Charleston, and Mount Pleasant Police Departments all bought in on a plan that cut bookings down on those charges by 73% since 2014, a 93% cut for simple possession of marijuana alone. Mount Pleasant Police Department Deputy Chief Stan Gregg says it forced a major change in philosophy while still enforcing the law.
They still have to appear before the court, and in the long term, it's getting the officers back in service quicker. It's not tying up the jail resources. It's not starting that cycle of taking somebody to jail where they have to post a bond to get out, and if they can't post a bond, they're in there, and then that compromises their employment, could possibly compromise their housing, their family situation.
For those who do end up in jail, the council focused on making sure the bond court process is more equitable, providing a defense attorney for anyone facing charges.
My charges were drug trafficking, which is a violent offense in the state of South Carolina.
Keith Smalls spent 19 years in the Department of Corrections and is now a leading voice on the council. He says that representation in bond court may have shortened his stay in prison.
Nobody really plans to get arrested, so likely 9 out of 10 of these individuals go in front of a judge without an attorney. Well, now because of the CJCC, that initial hearing has an attorney present, and that is humongous.
Is that a game changer?
A game changer.
And the CJCC is actually already starting to work on phase 2 of their mission, and that is looking at what happens after someone is arrested and how to prevent recidivism and the issues that cause it. Brad Franco, Count on 2.